is also army.
My suggestion was that let the applicants, etc., argue first because they file reviews and applications. And I'll give my points at the end.
Lordship, may I? Lordship, before starting the deliberation with these issues, I have one request. Lordship, I am appealing for Maharashtra Public Service Commission because Lordship, that order dated 13/3. On that day, we have already published the advertisement for 286 posts of Civil Judge Junior Division. And Lordship, we have allowed all the disabled PWBD persons because what happens, sir, there is no, Lordship, the rules.
Right, that whatever change is made that you.
Yeah, we made, but my anxiety is that because of that interim order continuation by Lordship, we are not able to hold the examination.
Madam, we are aware of that because of our interim order. Now all selection processes have been stalled.
Yes,
That we are aware of it.
yes, Lordship. So I'm seeking some direction because Lordship, thousands vacancies are there.
You are not an exception on the earth. You will follow whatever happened in India.
Lordship, my contention, whatever orders Lordships gave, we will follow that. But right now, let us continue with the.
That the law will be different for you.
No, of course, no, Lordship will follow that. But right now, let us proceed with our recruitment process. That is what my
Wait
contention.
for the main matter.
Okay,
Whatever will
Lordship,
happen.
please, Lordship.
Your Lordships, we have compiled some suggestions. If your Lordships allow me, I can pass over the suggestions in the written submissions form, your Lordships. We have also filed it on recorders.
No, you please give your suggestions.
Yes.
No difficulty. We will surely we require those suggestions. Follow this and give suggestions.
Your Lordships, we have given it in the form of a written submission, your Lordships. It's on record also, your Lordships.
Madam, Pinky and.
Your Lordships, allow me.
That's basically because we have put up lots of suggestions. Hand it over. Let's very briefly, let's adopt what we are adopting for purposes of group A officers in the government. The Lal Bahadur Shastri Mills itself academy, which, not that I'm saying use the academy, your Lordship, any national academy or otherwise, but to have a curated program at two levels. One, before Millards, at the time of legal education, Millards, to have a 6-month or 1 year Millards curated program for training. And second, Millards, to have a curated program after Millard's appointment in accordance with what is done with the group A officers. Millards, let me put it, that's a nutshell suggestion that we have for the reason, Millards, that otherwise Millards discrimination is writ large against women, against people who live in outside places, Millards, against people who have invested, Millards, substantial time and money. And Millards, the delay in the system, which means that the entire margin, Millards, of getting their promotions, etc., Millards, they will become roughly about 41 or odd, Millards, before they come to any higher judicial positions, Millards, which means, Millards, we are putting an end, Millards, and to this entire atrophy to the system. So, Millards, these in essence, Millards, are my suggestions that I can put forth, Millards, which I have put forth in writing from page 10, Millards, onwards of the note. Practice experience requirement may be incorporated as part of the training curriculum of selected candidates in the same fashion as the training given to selected IAS candidates at Lal Bahadur Shastri National Academy of Administration, Mussoorie. Proposal is to have post-selection curated exposure that ensures quality education and mentorship to the selected candidates. This practice experience may be structured in the following manner. These are the suggestions. Selected candidates undergoing training for Civil Judge Junior Division may be attached with district judges for practical training as an apprentice / law clerk / judge in training. In fact, the Center for Research and Planning, Millards, your Lordship's Center, Millards, has come out with this report recommending the introduction of LCRA district judiciary to further strengthen administration of justice at the subordinate level. It is recommended that selected candidates be attached to the district judiciary and or the High Court with remuneration as a law clerk for their training in administration of justice, legal reasoning, conduct, ethics, and enhancement of legal proficiency. At the same time, it is also necessary to examine the law clerk system and provide for the LADC scheme 2022 for a specific period. Now, a similar system has been adopted by Germany, wherein to qualify for judicial office, a candidate must complete a university degree, followed by preparatory training under Section 5B of the German Judiciary Act 1972. Under the said provision, preparatory training is for 2 years in a court of ordinary jurisdiction in civil matters at a public prosecutor's office or at a court with jurisdiction in criminal matters at an administrative authority with a lawyer. And then there are elective training modules available for aspirants looking to specialize. The Act further provides an option to extended part-time training to persons who are caring for or providing nursing care to at least one child under the age of 18 years or a spouse, life partner, or person related who per a medical certificate requires nursing. Because at present, we have separate state judicial academies, because undertaking these training processes, because different induction systems, etc. Because to have a uniform kind of system, therefore, to have it by the National Judicial Academy or by a permanent committee headed by the Honorable the Chief Justice of India as an ex officio chairman to continuously adopt and develop training modalities to perfect the lower judiciary. Certain changes we suggested in 5.1.2 in the university educational system. In brief, optional structured 6-month practice experience modules during the 3-year or the 5-year law degree as the case may be. Special degree courses, LU, BA, LLB program for adjudication and justicing. It's very imperative that we flag this as an issue, because once we do that, it becomes a line by itself, which takes itself all the way upwards. Then on the final count, the merit, competence and ability of a civil judge is concerned to both the bar and the bench. It is humbly submitted that this court may continue to see this, therefore provide incentive of scholarships and administrative leaves to civil judges, junior division, to pursue higher education in law and specialities domestically and abroad, provide opportunities, exchange programs, placements and deputations, and finally, continuous education and training, including by way of virtual training throughout the career. It cannot be at the first threshold only, because we continue and we are doing that process. Judicial academies are doing it. If we put it into a structure, that structure comes into a reality. Then if your lordship could consider the office of the Chief Justice. I am not saying any individual. I am saying only the
world, the training continues even after joining profession.
Yes.
In India only that you get a license and then you.
That's right, it should be for lawyers also. I would say this also. This is the engagement we are doing, because we are doing at different levels, but they are mostly at the unorganized levels. So therefore, a consideration of whether we could put this into a program, so that it becomes a necessary part of our existence, and a continuity and post-selection as far as judges are concerned. If they wait, their careers are over. They will not take up these lines. You will not have good people coming into the profession. You will not have women being able to come. Your lordship has already considered that at an earlier stage. Disabled and all, is yet another category which your lordship has to look at. The investment which has been put into this, if that has to be addressed, that can be addressed at an educational and a training level. That doesn't require them to be held off for 3 years only for this purpose. That's a continuing process. Yes, we have to consider that. I'm not saying we don't have to, by all means. But for that purpose, you can't hold them off pre-appointment. Have their appointment, hold them off. Hold them off for a year. Have that proper training through a proper process. If Germany does it, I'm not on Germany alone, we're India. But nonetheless, we require systems to ensure that we bring the best forward, and at the right age. Your lordships are constantly looking at the best judges and appointments are being made for them.
So from page 1 onwards, are the Law Commission reports, all of them against the 3-year rule? So that's page 1, page 2. Turn to page 3, my lord.
What is the ultimate suggestion?
The suggestion ultimately is centralized training, extensive training of judges, take them in after graduation and do extensive training for them for 3 years or 2 years, whatever. But they are a judge when they go for training. Then, my lord, page 3 is the All India Judges case, 2002. Again, my lord, on the same point. Now, my lord, go to page 4 from the bottom of page 4. That is the 1993 All India Judges case. It was of the opinion, page 5, top of the page, that 3 years standing at the bar as the minimum qualification. High Court after High Court saying that it is not necessary to have this 3-year rule. That goes on to page 7, page 8. Now, my lord, page 9 is the expansion of judicial academies. So that, my lord, in 2026, this your lordship knows, but I'll just quickly say, at page 10, bottom of the page, almost all the states except a few small-sized states have full-fledged state judicial academies. So, my lord, the time is ripe, actually, at a time when it is ripe to do training of judges whom you take in after, my lord, the NLUs they pass out from the NLUs. At this very time, my lord, we are sending them back into 3 years of litigation. Then, my lord, page 11 is the article by the retired director of the National Judicial Academy, suggesting in the middle of that page, para 13, that the 3-year practice requirement may be replaced with a mandatory intensive induction training program, etc. Now, my lord, the other aspect is judicial education in collaboration with universities. So, my lord, at the bottom of page 11 is, my lord, the American example of the University of Virginia. But if you turn to page 12, again and again, my lord, repeated recommendations are made that the Judicial Academy should collaborate with universities across the country. Bottom of page 12, my lord, is the French model. Now, my lord, page 13. The suggestion made here is, my lord,
Basically, you have compiled
the suggestions of
the
other.
opinion of all the law universities.
Yes, well, but there are some things that are interesting because it was missing in the learned amicus's presentation. So experimental learning, judges who are taken from day one through legal aid, clerkship and internship-based models, continuous evaluation and accounting, interventions by the NLUIs and the leading law colleges. That's at page 15, 16, 17, 18, 19, 20, right up to, my lord, page 24. No, past that, my lord. 26, Jodhpur, right across the country, my lord. The NLUI seem to be telling your lordship that you should not have the 3-year rule. This is, my lord, right up to page almost the end, yes. But I want to show your lordship something more. Give me a second. Now, my lord, look at page 35. This is, my lord, about vacancies. That when the examinations are held for the higher judicial services, there are a significant number of vacancies in the country. So your lordships are having a sort of a problem filling the vacancies for judges. Now, if you turn the page, my lord, page, my lord, 35, 36, top of the page, only 20% of the graduates from NLUI are entering law practice. Apparently, the experience of the national law universities is that if you have the 3-year rule, very few of the graduates from the leading law colleges would be inclined to go for judicial service. 36, the first paragraph, my lord, is a speech by Chief Justice Ramana, there's one. I find that very few students who graduate from the National Law School are interested in joining litigation.
Then you page 37, probably you are trying to point out that there is a conflict of opinion, and then your suggestions are at page 38 and 39.
Yes, well, but one last thing, Ms. The bench, the judgment of the previous bench was 3-judge. The previous bench is also 3-judge. It reverses the earlier judgment completely. And how was it done, my lord, without a reference to a larger bench? 3-judge reversing 3-judge. Maybe right, maybe wrong. We don't know, my lord, but it reverses it.
Lauren, for your lordships, read out for your lordships.
Plus, I want to add one thing, plus one point.
Thank you. Your lordships, Roman number 6, your lordships.
Yes, we have a copy of your suggestion.
Your lordships. So Roman number 6 till Roman number 9, your lordships. So these are the brief suggestions that we have placed on record, your lordships. Your lordships, maybe.
Your Lordship, proposed phased implementation framework, that it is respectfully submitted that a phased and time-bound transition mechanism is essential to ensure institutional stability and fairness to aspirants. Transitional cooling period up to 2029. That this Honorable Court may consider prescribing a cooling period till 2029, during which the 3-year requirement is kept in abeyance. Alternative experimental pathways are recognized. Judicial training infrastructure is strengthened. Phase 1 up to 2029, institutional preparation. That during this phase, a post-selection training program may be expanded. Legal aid-based experiential training may be introduced.
Thank you.
Law clerkship at the district judiciary level may be institutionalized. Phase 2 from 2029 post-selection legal aid training. That from 2029 onwards, selected candidates may undergo mandatory legal aid-based training, including engagement with legal services authorities, mediation and grassroots justice delivery systems. Phase 3 from 2030 onwards, integration with legal education. That from 2030 onwards, the final year of LLB, BLLB, 3-year or 5-year, may include a structured 1-year internship comprising 6 months at the district court, 6 months at the high court. This would institutionalize early exposure and reduce reliance on post-degree litigation practice. Phase 4 from 2031, pre-selection practice requirement. A pre-selection mandatory practice model may be introduced. Candidates may undergo structured practice prior to selection. That a nationwide system of law clerkship at the district judiciary level may be introduced. That such clerkship would provide a direct exposure to judicial functioning, strengthen institutional capacity. Serve as an alternative experiential pathway. Alternative framework, if the phase model is not accepted, that that without prejudice, a 2-year composite model may be adopted. 1-year post-selection training, that mandatory judicial academy training with structured modules and supervised attachments. 1-year structured mandatory internship integration with legal education. That the final year of LLB, BA-LLB, 3-year or 5-year may include a structured 1-year internship comprising 6 months at the district court and 6 months at the high courts. Special provisions for persons with disability, that it is respectfully submitted that persons with disability may be required to undergo only 1 year of mandatory practice, preferably post-selection. Such requirement may continue only until accessible judicial infrastructure is fully operational. Alternative pathways such as clerkship and research roles may be recognized. That it is further submitted that reasonable accommodation, accessible physical and digital infrastructure must be ensured as a precondition to enforcing any rigid eligibility requirement.
Lordship, may I submit? Lordship, I appear for.
I just have one addition before. Public employment laws and the Indian classical dream laws. The only public engagement that is available in legal practice is not this engagement at the judicial level and the appointment. And therefore, to perpetuate that situation and to, if take it away by putting in a 3-year gap is something which would impede the entire course of justice and the judicial delivery system, and also denial of affirmative action, which is available under the Constitution and your Lordship's judgments.
Lordship.
The second part only is one more. We need to have national exams at one level, state exams at different levels, different dates, and in a gap, which actually again puts a spoke in the wheel, is something also which might need to be addressed while your Lordship is looking.
Lordship, I appear for an intervener, Rahul Bajaj, and we have filed an. I'm sorry.
Yes, please. Yes, please.
Yes, Lordship, the intervention application number is 83490. This is in Bhumika Trust versus Union of India. I will straight away take my lords to the suggestions that we have given while
as my lord is deciding the practice eligibility criteria for 3 years, we are given certain suggestions on how the reconciliation between the All India judges and in re-recruitment of visually impaired judgments can be done. I'll straight away take my lord to para 16 of my IA, which is internal page number 8. Do my lords have it?
Yes, you recall the lordship.
I'm sorry, lordship? Yes, all right. Yes. Yes. So, Lordship, we have basically suggested 7 suggestions. One is basically to identify that the lawyer is lawyer with a disability. That is also given in the paper book. The second point that we have made is that in the in the panel councils as well as in the legal aid panels that are set up by high courts and district courts, there should be reservation for people with disabilities. Delhi High Court has already done this as part of its legal aid panel that I want to cite as an example. BNC basically takes care of that point. Then I'm also requesting my lord to issue directions to set up and have functional accessibility committees in high courts and in district courts, so that lawyers with disabilities can get the accessibility support and reasonable accommodations that they may require to discharge their professional obligations. Mike is- So sorry. Sorry.
I'll let you know when they're done.
Yes.
Go ahead.
Yes. Lordship, in para E, what we are requesting is Bar Council of India to set up an accessibility fund so that lawyers with disabilities can be provided necessary support in terms of sign language for deaf and hard of hearing, also the quieter rooms for invisible disabilities, and human support for persons with other disabilities. Assistive technologies, my lordship, is not covered within this, but that is something I would like to submit additionally. We are also requesting that regular sensitization of both lawyers, court staff, and judges be conducted on an annual basis, so that they are more sensitive to persons with disabilities and they understand the issues being faced by persons with disabilities. In Supreme Court, we are recommending that this can be done through SCEURA as well as SCBA. And the lordship, the other point that we have made is that the PSU and law firm experience has may be considered while calculating the 3 years requirement for lawyers with disabilities. The last point that I want to make, lordship, is basically Section 21 of Rights of Persons with Disabilities Act 2016 requires all establishments, and my lord, that definition is given in Section 2I and basically 2E and 2V. 2I defines establishment, where we are saying all law offices, which will include law firms or such other establishments as are notified within RPWD Act, to formulate and notify their equal opportunity policy and register it in line with the Act with the Chief Commissioner or the State Commissioner, as the case will be. If my lord would be pleased to allow the IA and take the suggestions on it.
Important, very vital issue you are raising.
Yes.
It is slightly different than the review application which we are considering. So maybe that we will deal with this issue independently and separately.
Okay.
Your Lordship, if I may just add, Your Lordship's 2 aspects. The suggestions which have come are very good. We have
My Lord,
on our side, Your Lordships, we have examined all the rules of various high courts. And what we find is that most rules have a hybrid of situations where there is an entry-level practice that is required, and then the training is required. We have given in our suggestions, Your Lordships, 2 high courts specially, Assam High Court as well as Punjab and Haryana High Court, where they have a staggered training period, which is inducted, Your Lordships, and depending on the number of years of experience you have, that is the proportionate training that you will receive post-induction, Your Lordships. And this is specifically suggested in view of the fact that, Your Lordships, in all other employment spheres, especially in civil services, Your Lordships, all the people go and take those exams, your lordships, and in the judiciary, only the people who do not succeed in civil services, they come. It is never their first choice, your lordships. And secondly, for women, especially your lordships, by the time 3 years finish, their families do not want them to take any professional jobs, your lordships. So this restriction, your lordships, is actually taking away both the merit of the service and the dignity of the service as well, your lordships. And it actually amounts to an Article 14 violation in comparison to other services, your lordships. So we have suggested, and we have given it to the learned amicus also, your lordships, the staggered training program to remove the bottleneck of access. Let us allow us to take examinations, and depending on how much ever experience we have, that much training will be given. And your lordships will see that the Assam model has practical and adoptable model, your lordships. The candidates with prior practice undergo shorter training, whereas candidates without such experience undergo extended structured training. And in that, they have rotational court attachment, they have institutional training, and they have supervised adjudication. So this is a model which has already been formulated. In Punjab, your lordships, they undergo an entire 1-year training as soon as they are inducted. Same as civil services, your lordships. So these are the 2-3 points that we have suggested, and a detailed, your lordships, roadmap. And my learned friend's suggestion that there should be a judicial academy looking at it centralized, in a way that might not be workable, your lordships, because all the high courts have peculiar language and cultural and social aspects, your lordships. So it probably will need to be worked out at the high court level, is my suggestion to your lordships. Grateful, your lordship.
Lordship, may I just make 2-3 submissions? May I just be permitted to make 2-3?
Your Lordships, may I please be allowed? Your Lordships, I filed an intervening application back in March with regards to women with disability in the 3-year practice. Your Lordships, I would just try to raise a few parameters with regards to concern where accessibility, safety, and societal pressure is concerned, your Lordships. Lordships, please be considered that where women with disability are concerned, their practice is largely dependent upon how accessible the infrastructure is and how their families pertain to their safety concerns and societal pressure that they have, which already hinders their professional mobility under Article 19, your Lordships. Your Lordships, please be considered that it's a compounding disadvantage and an intersectionality between gender-based bias and disability-based concerns, your Lordships. Please be considered that it's humbly prayed, your Lordships, that before any decision is taken, this please be considered, your Lordships.
All right.
My lord.
Question is almost same as Mr. Bajaj, I think.
I didn't get that.
My lord. We'll consider that.
My lord, I am appearing for High Court of Karnataka.
With your lordships, kindly.
Online, my lord. We have filed application.
We don't need views of High Court at this.
No, we are in difficult.
We are not, we are
position,
filed an application, my lord. Some urgent application is filed, seeking permission to withdraw the notification and issue a fresh notification. My lords may kindly have a look at our application. We had issued a notification, my lords, inviting applications. Thereafter, Government of Karnataka has come out with an order saying that we should have internal reservations. Therefore, my lords, a fresh notification requires to be issued. Just as a measure of abundant caution, my lords, this application is filed, seeking permission to withdraw the notification which is issued earlier.
All right, allowed, IA allowed, the High Court is permitted to withdraw the advertisement and issue a fresh advertisement strictly in accordance with law.
Great.
May I
My lords,
please?
I have moved an application on behalf of law officers working in PSU. My lords, we are seeking parity with respect to the exception carved out to law clerks. My lords, the law officers working in PSU as well are engaged with respect to work.
Them at par with law clerks. Law clerks are working with, they are integral part of.
My lords, the reason we are seeking is this, that I'm preparing notes, the work profile, my lords, of a law officer in PSU would be, we have a fixed client. I'm preparing notes. I go to the court, brief the senior.
With respect to this review application account.
My lords,
It's not with respect to this review application.
no, my lords, I've moved an application separately and I've served a copy on the learned amicus as well.
This is not an issue with reference to the review application.
My lords, we'll take.
The review are confined only to the 3 years. 3 years. Condition. Mr. Jaideep, you are also appearing, what?
No, my lord, I am for a high court, my lord. I heard what your lordship said, my lord, so I was, my lord.
Exactly, that,
May I be permitted, your lordship, just two submissions, your lordship, before
Yes,
London amicus start with your lordship, just two submissions, if lordship permit me. I filed two IAs before this honorable court on this premise that my higher qualification is an impediment. So your lordship has already considered, High Court has not considered our. Your lordship, I am here in review, your lordship.
See, we have been telling you regularly.
Yes,
that
your
you
lordship.
approach the High Court.
Absolutely.
And we have told you enough times.
High Court has not considered our case.
Then
They
you
said that
go before
you just
the
try your lordship, I'm just on different point.
Judicial side go before the.
Today I am on purely on 3 years issue so far as review part is concerned. Dropping that issue, I'm not touching it at all. Genesis of the entire case is para 56, your lordship, of the judgment dated 30th of May 2025. And this is born out of Article 233(2) and 272(b) of the Constitution of India. Reason being, the Law Commission's reports have considered, primarily in the Shetty Commission report, that 7 years and 10 years practice at bar is for the higher judicial examinations and the High Court level for 10 years as a experience as a lawyer or the legal practice, your lordship. So that is the genesis that a civil judge or at the lowest rung, there must be some experience. And this has borne out of para number 56 of the impugned judgment, your lordship. This is under review before this honorable court, and this is the impediment which has come up now. And on that parameters, your lordship, 3 years criteria has been put in it. So just two submissions to that effect, your lordship. Just wanted to give this maybe for this honorable court. This is on a France model, on a Denmark model, your lordship. And 2-3 suggestions which I have also, I'm just going to give you lordship. In France, your lordship, it is judges are selected through a competitive examination and then undergo 31 months of professional training before appointment. So my submission is that extensively this has to be. And second one is lordship, on Denmark basis, law graduates can be recruited as deputy judges directly after school or after gaining some experience. So this is not there in our country, your lordship. Some, your lordship, just 2-3 lines here, I'm just putting it, and then closing it. They assist judges, undergo 3 years of training, and must pass a final examination before becoming permanent judges. This model may be useful in India as it can improve judicial strength, reduce case pendency, and provide financial security to young law graduates. So one step ahead of it, that instead of many other options, one more options may be given so that the aspirants can directly be absorbed as deputy judges, they can assist the civil judges, and thereafter final examination has to be there so that they are fully equipped. Your lordship, at the lowest level, it is the best acumen we need. Reason being, the judgment travel up to apex court, your lordship. That's why the training at the lowest level, as well as in the law schools, and also, your lordship, for the training in the judicial academy is a must to getting into. I'm so grateful, lordship, always.
My lord, now I'm not treating this as adversarial at all. So I'll just, my lord, since my.
Two aspects, just you can.
Yes.
One is suppose the 3 years to be returned,
Yes.
then how to deferment, how to implement.
Yes. So, my lord, in fact, your lordship might recall on the very first day when your lordship took it up, I had given a note of suggestions. One of my suggestions was that I can understand today they might be going through some difficulties. Your lordship may have it as a staggered basis. For this year, for instance, in 26, you may not need any experience. 27, 1 year, 28, 2 years, and then finally go up to 3 years. Because, my lord, in my respectful submission, the judgment of your lordships of May 25 has considered this aspect in very great detail. My lord, it's not as if it's just something that your lordship, and the high courts, which are the institutional courts, which are more conversant with this than any of us, and your lordships have that experience, about how the judiciary must function, is their views must be taken into account. And overwhelmingly, the High Court said,
High courts we know very well.
That's right, correct.
The moment we give a judgment, they will never take.
No, my lord, I'm talking about pre-judgment. I'm talking, not after that. So your lordship may not take into account what they are saying after 25. I'm saying what led your lordships to the 25.
Must have been taken.
Yes, so that's what I'm saying. They were not at all influenced. Now, my lord, your lordship will also see that till 1993 judgment of the Supreme Court, which said 3 years experience is required, even prior to that, always, my lord, the judiciary had people with experience coming in, whether 2 years or 3 years. In fact, pre-independence onwards. 93 judgment said 3 years. Then, my lord, 2002 changed it to no experience required. So only for that limited period, my lord, we've had an experience of, let us say, my lord, 10, 12 years, where there was people with no experience, and the High Court found that it was not good enough to function as a judge. Now, my lord, let us look at what some High Courts are saying about experience. Problem is that if Assam says, if you have 3 years experience, you will undergo less training. Now that 3 years experience is not actual experience in court. The person may get enrolled today, sit at home. I'm not saying it will happen in every case.
No, this is the only thing happened.
Yes.
That they will get enrollment.
Sit at home and prepare for 3 years.
Lawyer will issue a certificate.
Yeah, correct.
You don't have any method.
In fact, there's no certificate required.
You don't have any system in the district.
Certificate is now required after Lordship's judgment. So earlier there was no certificate required. All you have to say is from the date on which I enrolled with the provisional enrollment with the Bar Council, I can sit at home, I can prepare for the examination, I did not go to court, and as soon as my 3 years period, and if I qualify, and I can then say, I have 3 years experience as a lawyer, so please in fact cut down my training further. My lord, that these are the kind of issues that your lordships are faced with. So, but I do believe, my lord, that for certain categories, if not a relaxation in the eligibility can be 3 years. But, my lord, for suitable, for instance, my lord, relaxation in marks for, my lord, persons with disabilities is a very valuable suggestion. Clerkships, my lord, for them and for women as well, my lord, judicial clerkships and preferences in that. All that, my lord, must follow. That I think your lordships would, I think, agree with me and with the other side completely. But if we carve out categories of people with not 3 years and 3 years, then there'll be any number of categories who will want that access.
How to implement it?
Yes.
It is implemented in 3 pages or in stage.
So given to your lordship, although the note is, or shall I just? Yes. My lord, what I'd said was, just give me my last note. It is given to my lord. My lord, just give me one. Note 1. No. Yes, no. No. What did we say to the court about?
No, the only issue is post or pre-selection. The rest will also nobody is in any issue about. The question is, should it be before or after that?
None of us are rooting.
No, nobody is saying don't have it.
The Assam model, we are saying
My lord, this is what I'd.
bottleneck itself should go. Eligibility should go.
My lord, I'd said staggered implementation in the transition period is the heading, while retaining the conditions for recruitment as laid down in All India Judges, so and so the 25 judgment. In the transition period of the next 3 years, fresh law graduates may be permitted to appear for the Civil Judge Junior Division examination. Candidates who clear the said examination shall undergo requisite training in the state Judicial Academy. After the transition period of the 3 years, the 3 year experience may be made mandatory. That's what they are saying. That was one of my suggestions. Alternatively, practice period of 3 years prior experience can be 0 years, 1 year and 2 years respectively for aspirants appearing for the examination in the next 3 years, i.e. 26, 27 and 28 respectively. Thereafter, 3 years practice rule will apply uniformly. This is what I will not suggest to you, Lordship.
All right, we will examine.
Obliged.
Very great. Most grateful.
Lordship, I am IA 15143 in 301. Lordship, my humble prayer is that aspirants like me are getting age barred due to there being no exams held since the past year. If your Lordship may extend the upper age limit from the day of All India Judges Association on 20th May 2025.
We'll see what is going on.
That may be necessary because
Obliged, ma'am.
elections have taken place during this.
Also, the disabilities issue will be posted separately, my lords, for the consideration, my lords.
All right.
Great.
My lords, I have filed an IEA for intervention on behalf of junior clerks in lower judiciary, my lords. I've been working for over a decade in Odisha, Cuttack District Judiciary. But I've been working as a junior clerk in District Sessions Court in Cuttack, Odisha, my lords. But because I've been
About this separate category, whether you are eligible or not, it is not the scope of the review.
I have. Okay.